Yes, Mr. Westwood. You can assume that we are reasonably familiar with the background since we sat on the last trip to this court, and my lady has also sat on the previous one to this court, and we have read the skeleton arguments and the judge's various judgments. I think there are three altogether. There's the substantive one, there's the consequentials, and then there's the clarification.
Yes, indeed, my Lord. I'm very grateful, my Lord. My Lord, as you will appreciate, I appear with my learner friend Miss Page for the appellants, and my learner friend Mr. Day appears on behalf of the respondents. Lord and my lady, just in terms of some brief housekeeping points, we'd noticed that the matter was listed both in the appeal in the eviction proceedings and in this appeal.
Oh, no, it's only this appeal.
It is only this appeal, my Lord. And I think it was only called on in this appeal, but we thought it only right just to note that we'd spotted that, and that's been corrected, I think. My Lord, secondly, transcription. I understand that today is being transcribed, and we've been asked by the transcribers if it's possible to have a short break.
Sorry.
Well, there we are, my Lord. I made the request. My Lord, the final one was materials, but I'm very grateful you've indicated that you've had an opportunity to read the materials, and
yes.
I'm grateful for that. So, my Lord, subject to that, the course I was proposing to take in my submissions was as follows. First, to introduce the appeal and to make some headline points. Secondly, some brief comments on the relevant legal principles, though I don't anticipate that there will be much dispute about those legal principles. But the third point then is just to address the point which my learned friend appears to be making as to whether the appeal is an irregularity, and then fourth, to address the grounds of appeal. So, my Lord, in terms of introducing the appeal, my Lord, as you rightly note, this is just the latest piece of litigation in what is being a very long-running dispute between the Brakes and Chedington Group. And I know my Lord Justice Lewison and my Lady Justice Asplin has made comments about the length and complex nature of those proceedings in the judgments, both in the eviction proceedings and also in the bankruptcy application and the liquidation application.
And we also did the confidential documents.
The confidential documents. Well, I in fact looked up on Westlaw as to the number of related cases to the judgment, to the eviction appeal, and that produced 34 reported decisions, which gives an indication as to quite how extensive this litigation has been. Lord, this appeal is brought with the permission of Lord Justice Newey from the order of Judge Matthews dated the 25th of November, by which he ordered on the respondent's application my clients, the trustees in bankruptcy, to apply to be joined to the eviction proceedings and to take certain steps in those proceedings. Now, obviously, my Lord, my Lady, this court is very familiar with the eviction proceedings, this very constitution having heard and determined those proceedings. And because you will recall, my Lord, that what you did in that appeal was allowed the appeal to the extent of declaring that the Brakes' exclusion from the cottage, Ax Nolla Cottage, was unlawful at common law.
Yes.
And that Chedington had no right or title at common law to justify any interference with the Brakes' exclusive possession of the cottage without a court order. And then the court then made an order, having made that declaration. Perhaps if I can just, the court is no doubt familiar with that order, but it's in Core Bundle, tab 7, page 169. Page 169.
Yes.
And one sees the declaration that we just mentioned in paragraph 1.
Yeah.
The declaration, and then the order. Paragraph 1 allows the appeal, and then there's a series of consequential directions. Paragraph 3 is for the Brakes, the appellants, to file and serve written submissions about consequential relief that they say is justified, and they're to do that by the 31st of October of last year. And then it's paragraph 4 that in a sense gives rise to this appeal, because paragraph 4 makes provision for the trustees to make an application to join the proceedings, if so advised, by that date specified there, the 21st of November. And at the same time, if they do that, to file and serve written submissions and or a witness statement, setting out their position on the question of any further relief in these proceedings sought by the applicants, so sought by the Brakes. And then there follow various directions consequential on that, with provision for the possibility of a hearing. And, my Lord, this appeal arises out of that provision for the trustees to make an application, if so advised. The trustees considered the matter.
And decided not to.
They took advice, as we've seen from Miss Kick's witness statement. And having taken that advice, they took the decision that they were not going to make an application to join the proceedings. Well, what then happened was that led to the respondents making an application under Section 303 of the Insolvency Act and or the inherent jurisdiction of the court for an order directing the trustees to apply to join the eviction proceedings, thereafter to seek an order for possession of the cottage and to oppose ground 3 of the appeal in the eviction proceedings, which was for an order for possession in favour of the breaks. And in the event of obtaining an order for possession, thereafter to grant a licence to Chedington, terminating on the earlier of 30 days from the hand down of judgment in the bankruptcy application, or dismissal of the bankruptcy application in the event that the Supreme Court allows Chedington's appeal from the order of this court.
Can you just, maybe this may be a question for Mr. Day, but why did Chedington not simply ask the trustees to sell the cause of action to Chedington? Let them pursue it.
Well, Lord, I'm not sure of the answer to that question. Perhaps. My Lord, I'm afraid I can't assist you on that at the moment. I can make inquiries about that if that's something the court would like assistance on.
Well, it's just curious.
Well, yes, but it hasn't happened, I'm afraid, is the short answer to that point. So, my Lord, that was the application, and it provided that the application as it was made was provided that Chedington would pay a licence fee of £3,000 a month in respect of that licence, and if the parties couldn't agree the other terms of the licence, there was to be liberty to apply. And, Lord, as you will have seen, Miss Kicks set out at length in her witness statement the position of the trustees, explaining that they had considered the position, that they had taken legal advice on it, but that ultimately they had decided, for the reasons that she set out in that witness statement, not to make an application to join the eviction proceedings. And when the application came before Judge Matthews, subject to one point, he granted the application and held that the trustees' decision not to apply on the basis of the arrangement that was proposed was perverse, such as to engage the jurisdiction under 303. And the one variation to the application was that in the event that the trustees were joined and obtained a possession order in their favour, they had the option, but were not required, to grant a licence to Chedington for the licence fee of £3,000 per month. So, subject to that one variation, that is the order that is.
And if I understand the position correctly, receiving £3,000 a month from Chedington is not going to produce any dividend for creditors.
Correct.
The estate is so hopelessly insolvent that it will just get swallowed up, presumably, in trustees' fees.
My Lord,
I think I read somewhere there's £500,000 owing to Mr. Swift.
To Mr. Swift alone, Lord. Lord, that's something I'm going to come on to, and I'll take you to the evidence as to what the position it was before Judge Matthews as to the financial position of the two bankruptcy estates. But yes, that is our submission, that is what the evidence demonstrates. That the £3,000 licence fee, even if the licence fee would be paid for, say, a year, so that it were £36,000, it wouldn't make any difference in terms of a return to creditors. Well, and that was certainly part of the calculation of the trustees in bankruptcy, as Miss Kicks makes quite clear in her witness statement on the application. Well, before coming on...
There's one other thing I would like some help with, because I'm not sure that I really got to the bottom of it. Let us suppose, and there's a lot of supposition here, let us suppose the Supreme Court upholds the decision of this court. The breaks have standing to challenge Mr. Swift's arrangements. And let us suppose that the breaks challenge to those arrangements succeeds. The partnership liquidator has sold the beneficial estate, and nobody's challenging that, as far as I understand it, because the breaks don't have standing to challenge it. Nobody else is. But what happens to the beneficial interest? Where is it?
Well, on the face of it, it's with Mr. Swift.
Personally?
Personally.
Yeah.
Because, of course, one of the issues is whether or not my clients, as the successor trustees, succeeded to his interest in the cottage.
And they would only succeed if it were part of the bankruptcy.
Absolutely, my lord.
But if it were not part of the bankruptcy estate, he still bought it.
He did. He did, my lord. And presumably that's where that's where it would be.
So success or failure in the challenge to Mr. Swift's arrangement is not going to affect the location of the beneficial interest. Either it will be, well, it will be in Mr. Swift, either as trustee, in which case it would pass to you,
Yes.
or personally.
Yes, well, because as your
And
lordship
again,
says,
if I've understood the facts correctly, Chedington has actually paid the £500,000.
yes.
And I suppose that must have gone to the partnership liquidator?
As
Was it the back-to-back arrangement?
My learned friend will know more about this than I do, my lord, but I imagine that that is right, because it was a back-to-back arrangement, as I understand it. The money was provided to Mr. Swift, who then paid it on to the liquidators of the Stay and Start
Yeah, no,
partnership.
that's what, as I understood it.
Yeah.
All right, thank you.
Well, before coming on to address the grounds of appeal in detail, can I just highlight what the trustees submit are some key points about the position in this case? Well, the first is this, that by this court's order of October of last year, that order simply provided for the trustees, having considered the matter and taken advice, that if they did want to make an application to join, then they were to do so by a particular date and a particular time and to set out their position. It did no more than that.
Yeah, putting it crudely, it was a put up or shut up.
It was more, absolutely, quite. And having considered the matter and having taken advice, the trustees concluded that they didn't want to take up that invitation. And they did so because, as Ms. Kicks sets out in her witness statement, they didn't consider it to be in the best interests of the creditors of the bankruptcy estates, and also because of concerns about their duty to act independently. Notwithstanding that view, having been reached with the benefit advice, the trustees have nonetheless been directed by the judge's order to take steps to apply to join those proceedings to which they haven't previously been a party, which have been on foot for more than 4 years, during which time nobody else sought to make them a party to those proceedings. And those proceedings have been, not only have they been to trial, but they've also been to this court on an appeal from the final order that was made at trial. And my lady, not only have the trustees been directed to make an application to join those proceedings, they've also been directed to make written submissions in support of specific relief and in opposition to relief sought in the grounds of appeal. They've also been directed to attend any oral hearing that might be directed and to make oral submissions at that hearing. Well, they've also been ordered, and this is the consequential order of the 16th of December, not to put before this court on any application submissions setting out certain concerns which they have, again having taken advice, as to whether they are in fact entitled to the relief that they've been ordered to apply for in the event that they're joined.
Yeah.
My lord, they've been directed to do all of that on the basis of funding and an indemnity as to costs, which has been offered to the court by way of undertaking from a party which isn't a creditor in the bankruptcies, but which is a party to the proceedings to which the trustees have been directed to apply to join. And that party, and that's Chedington of course, has a direct interest in the relief which the trustees have been ordered to apply for. And what it seeks to achieve by that relief, through the use, we say, of the trustee's office, is a continuation, pending determination of the bankruptcy application, of the status quo since January 2019, in which it has been in occupation of the cottage. And it appears to accept that it can't achieve that objective through its own efforts and rights, having lost the appeal in the eviction proceedings. And so it now seeks to do so by funding the trustees to use their powers and indemnifying them against any adverse costs in doing so. And the basis for ordering the trustees to do all of that is that their declining to take those steps in the particular circumstances of this case was so unreasonable that no reasonable trustee could have come to that view, so they were acting perversely. And it's our submission on this appeal that to dismiss the concerns of very experienced trustees in such circumstances as absurd and perverse is unprecedented, and we submit wrong. With that introduction, Lord my lady, and I'll develop those points in due course, can I now turn to make some brief points about the legal principles involved? Well, obviously in terms of the relevant section under which the application was made, that's section 3031 of the Insolvency Act, and I'm sure the court is familiar with that. That is in the authorities bundle, tab 1, page 6. And it's just subsection 1, and so I'm sure it's well known. If a bankrupt or any of his creditors or any other person is dissatisfied with the act, omission, decision of the trustee, he may apply to the court. On such an application, the court may confirm, reverse, or modify any act or decision of the trustee, may give him directions, or may make such other order as it thinks fit. That's the statutory provision. And, Lords and my Lady, I was just intending to refer very briefly to 2 passages in the authorities. Again, no doubt, well familiar to the court. The first is Bramston and Hope, which is at tab 10 of the authorities bundle. And this was an appeal from by a trustee in bankruptcy from an order suspending the bankrupt's discharge from bankruptcy, which had been made under sections 279 and 303 of the 1986 Act. My Lord, it's the judgment of Lord Justice Kitchen, which appears at page 148 of the authorities bundle, page 1737 of the report, starting at paragraph 68. And I wonder if I could just invite the court to read paragraphs 68 and 69 over the page.
'68, did you say?
68 and 69,
Yeah.
please. So,
What does the intensifier so add to perversely?
well, my Lord, again, that may be, and I was going to come on to this in terms of the next point on legal principles, which is the difference between wrong and plainly wrong. Another intensifier that's used. Well, in my submission, it makes no real difference. And the court will see the point. Absent bad faith or fraud, and there's no suggestion that we're in that sort of terrain here. In order for the court to be to interfere with the exercise of a trustee's powers and discretion, it has to be satisfied that the decision was perverse in the sense that no reasonable trustee could have come to the decision that they came to. Well, that is borne out in the second of the authorities I was going to show you, which is Edengate, and that's tab 18 of the authorities bundle, another decision of this court.
Sorry, which one? 19?
Tab 18.
80.
Edengate, page 383. I mean, my lady, this was an appeal on section 1685 of the Insolvency Act 1986, and that's the corresponding provision in corporate insolvency. So there are some very minor differences in the wording, but substantially the same. And as my lady, Lady Justice Asplin said in the appeal in this case, Brake and Lowe's, it's well established that the same test for intervention by the court applies in relation to both the actions of a liquidator and those of a trustee in bankruptcy. Ultimately, in this case, the court had declined to set aside an assignment by the liquidator of a claim against the appellant. And Lord Justice Mayles comments on the test on the merits at page 950 of the report, and that's page 393 of the authorities bundle. And again, perhaps if I could just invite the court to read paragraphs 43 to 45. I'd also just draw the court's attention over the page at paragraph 50, if I may, to the passage in the middle of that paragraph, where Lord Justice Males says whether a liquidator's act is perverse in the sense described in the authorities is an objective question. So the judge in that case was entitled to conclude, if the facts justified it, that the liquidator's decision to assign the claims was not perverse, even if the reason which he gave for his decision were unsatisfactory. So, my lords, my lady, there's no, as I said, no suggestion of bad faith here. So the test is whether the trustees have done something so utterly unreasonable and absurd that no reasonable man would have done it. And in my submission, as Lord Justice Males put it, that is a formidable test that has to be overcome. My lord, it's our submission, for the reasons that I'll come on to, that the judge was wrong to reach the conclusion that that formidable test was satisfied in the circumstances of this case.
And Edengate, like Eden Note, was a case where the office holder had sold the claim.
Yes.
The question was, had he sold it to
Yes.
the right person?
Yes.
And in Eden Note, the court said no.
Yes.
In Eden Gate, they said he was entitled to sell it to
Yes.
the litigation funder.
Yes. Quite, my lord. My lady, the only other point I was going to make on legal principles is as to the correct approach on an appeal. I'm going to take that very briefly because obviously I'm well aware that this court will be extremely familiar with the right approach. Well, we say that this court can interfere with the judge's decision if it's satisfied that he went wrong in principle or he was wrong in the conclusion that he reached. Lord, again, I slightly foreshadowed this in saying that about the debate between the difference between wrong and plainly wrong. In our submission, my lord, when one is dealing with an evaluative judgment of this nature, the test is simply whether or not the judge was wrong, and plainly, the intensifier plainly doesn't add anything. My lord, if I need authority for that, one can see that in the Sprint Room case that's in the bundle, but subject to that, I'm not proposing to spend any more time on that. My lord, in the context of an appeal from a finding that 303 was engaged, we do submit that the following considerations apply on an appeal. As we've just seen, the relevant threshold for interference is perversity, absent bad faith, which doesn't arise. And that involves the court, so Judge Matthews, in an evaluative assessment of whether the trustee's decision was perverse, in the sense that no reasonable trustee would have come to it. And that is an objective test. And we say that such a test necessarily implies an absence of any objectively reasonable or rational justification for acting in the way that the trustees chose to act. And it follows in our submission that in finding that the trustees did act perversely, the judge concluded that there was no objectively reasonable or rational justification for the trustees not applying to join the proceedings. And it's our submission, and we invite this court to conclude, that there were indeed objectively reasonable and rational reasons why they didn't wish to seek to be joined to the proceedings. And if this court is satisfied that any of those reasons were reasonable or rational, then it must follow that the judge was wrong, the threshold requirement of perversity couldn't have been met. And in those circumstances, it's our submission that the judge was wrong to find that the trustee's decision was perverse, and that enables and indeed requires, in our submission, this court to intervene. And so the position isn't one of it where it's simply said, oh, it's not good enough that this appeal court might have reached a different decision. If you are satisfied that we had a reasonable justification for not joining the proceedings, then the perversity threshold cannot have been met, because objectively considered, it cannot have been perverse to act in the way that the trustees did. Well, that's all I was proposing to say on legal principles. Well, the final point before coming to the grounds in more detail is a preliminary point about whether or not this appeal is an irregularity. And my learned friend says that, to quote paragraph 4 of his skeleton argument, that this is a, quote, odd appeal. And he refers to comments made by the judge when he dismissed the trustee's application for permission to appeal back in December of last year.
This is on the basis the trustees asked for the court.
Yes. Yes.
And they have court protection.
Yes, absolutely, my lords. And the judge referred to Londonderry's settlements on that. My first point on this, my lord, my lady, is that other than as an observation, it's not clear what, if any, relevance the point is said to have to the appeal. But leaving that to one side, in any event, in our submission there is nothing irregular about trustees in bankruptcy appealing an order made against them on an application under section 303. Well, as I indicated, the point picks up on comments made by the judge and his reference to Londonderry's settlement. And just to show you that, that's in the core bundle, tab 6, page 71. This is the hearing, the consequentials hearing before the judge on the 6th of December.
Sorry,
It's in the core bundle, my lord, tab 6.
Core?
Core, tab 6.
Beg your pardon.
Page 71.
Yeah.
And the judge deals with permission to appeal at 55 to 57.
Yeah.
And at 56, he says there's something, perhaps something rather incongruous in seeking permission to appeal at all. And then in 57 is where he says that their position is more difficult to understand, since they emphasise they'd implement the direction of the court. And it was the reassurance of that direction they sought. And then there's a reference to the law of private trusts and Londonderry settlements and an appeal by trustees who've been given the direction is an irregularity. My lord, in fact, of course, this wasn't an application by the trustees for directions from the court at all. They had not sought the reassurance of the court's direction. They had done what they're often told to, or regularly told to do, which is you exercise your own discretion, you make your own decisions. They had done that. And it was the respondents who had made an application under 303 that they'd be directed to take steps which they themselves had not wanted to take. As for Londonderry, just to deal with that very briefly, that was a quite different case. My lord, unless the court requires, it's in the bundle, but I wasn't proposing to take.
Quite apart from anything else, the trustees were ordered to pay the costs and are not entitled to recoup those costs from the bankruptcy estate. They have an obvious financial interest in pursuing an appeal.
Quite. And as I say, my lord, even in Londonderry, of course, where Lord Justice Harman and Lord Justice Danquets, I think it was, said it was an irregularity, they still went on to allow the appeal. It didn't have any effect on whether or not the appeal was allowed. So, in my submission, it's just not clear where the point goes other than as an observation. So, Lord, unless there's anything further on that, I wouldn't propose to take up any more time. I'll move on to the grounds of appeal.
Yeah.
My lord, we raised two grounds of appeal. The first is dealing with the judge. We said the judge was wrong to hold that it was difficult to see the downside to an application to intervene, such that the trustee's decision was not just open to criticism, but that it was perverse in the sense that no reasonable trustees could have come to that decision. And in support of our appeal on that point, we rely on 3 points in particular. Well, the first is that we say the judge failed to have any proper regard to the trustees' legitimate concerns about becoming involved at this stage in potentially protracted, time-consuming and expensive litigation. Well, and central to the judge's conclusion that it was difficult to see the downside to an application to intervene was his apparent view that the proposed application would be straightforward. Well, we refer to expressions of that view in the additional note that we put in footnote 1, but in particular, in the section of his judgment headed assessment, and this is core tab 5, page 55. Page 55, paragraph 55. You see that in the first sentence of that paragraph, in this case the trustees have funding, indemnities, encouraging comments from the Court of Appeal, and a clear opportunity to monetise the cottage for the benefit of the estate. And that comment about that the trustees had encouraging comments from the Court of Appeal reflected what the judge had said during the hearing itself. And I'll just give the court the reference to this, if I may, was that whilst the trustees couldn't be certain of success on an application, the judge said this: there is no comment that any judge has made to suggest that there would be any problem. And that's supplementary bundle, page 69, lines 19 to 20. So just show you that. So supplementary, page 69. Where the point is made on this page that the application seems a somewhat unusual application and not one which will necessarily succeed.
Right.
That's
So this is Miss Page, in effect saying, well, the application to join might be opposed.
yes.
And we now know that it is.
Well,
tooth and nail.
indeed, my lord. And you have Judge Matthews making the comment he does at lines 19 to 20. Well, you can't be certain, I suppose, like anything litigation, but he goes on to say no comment any judge has made to suggest there would be any problem.
Yeah.
And as a consequence of that, my lord, we say the judge wrongly dismissed our concerns about becoming involved in protracted and time-consuming litigation. My learned friend says in his skeleton that we haven't been ordered to apply to intervene in time-consuming or expensive litigation, but only in respect of one ground of one appeal. And of course, my lord, it's obviously in the respondent's interest to present the point as one which is straightforward and simple. But what the experience of this litigation shows, I think I can fairly say, is that little is straightforward or simple. This is, as various tribunals have referred to, my Lady Justice Asplin and Lord Justice Lewison, and the judge himself, this is extensive. I think the word the judge used was sprawling litigation. So there are real concerns that we will get drawn into time-consuming and expensive litigation. That was a material factor in the trustees' decision. And in our submission, the trustees were, in the exercise of their commercial judgment and discretion in the management of the bankruptcies, perfectly entitled to take the view that if they applied to intervene, they were at risk of being sucked into time-consuming, contentious litigation. And that's particularly so, whereas we'll come on to, and as my Lord Justice Lewison has already adverted to, they took and take the view that there is no practical benefit to creditors from the course of action proposed. And indeed, Miss Kicks made that point in paragraph 16.2 of her first witness statement in opposition to the application. And my lady, we do say that events since the order have borne out our concerns. As this court's well aware, there was a directions hearing in the eviction proceedings and in this appeal in May. Now, that was adjourned at relatively short notice from an earlier date in March due to unavailability of the Breaks Council. And it's right that in the event, the hearing in May was a short hearing in terms of the time we were in court. But it was a hearing which involved all of the parties in substantial work and the possibility that a different approach might have been adopted. We all had to come along and prepare on the basis that a different approach might have been taken. And all the parties put in written submissions and attended that hearing. And in addition, the court may recall from the reply submissions that were put in by the Breaks in the eviction appeal in January of this year, and my lords, my lady, just for your notes, the reference to that is supplemental bundle, page 298.
These are the grounds of opposing the joinder.
Yes, there were more. And of course, what then happened was there were also written submissions were also put in for the directions hearing, which to an extent repeated or elaborated those points. But what one sees from those is that the Breaks have advanced a considerable number of what they describe as preliminary objections to the joinder application, leaving aside, for present purposes, their arguments about title, about the trustees' title, and whether even if joined, the trustees have a valid claim for possession. And if the trustees' application to join is to go ahead, then obviously those preliminary objections will need to be addressed and determined in due course. Now, it may well be, ultimately, that they're decided in the trustees' favour. But I think it's fair to say that they're unlikely simply to be dismissed as frivolous and without any real substance. And that, of course, is before one gets into the question of whether or not the trustees would be entitled, if joined, to an order for possession in their favour. Again, the trustees might prevail on that, but at least to the trustees, again having taken advice, it does not appear to be an entirely straightforward proposition. And as such, we say that just bears out the trustees' concerns about being drawn into time-consuming and protracted litigation. And those concerns...
With the potential for another trip to the Supreme Court?
Well, yeah. Possibly, my lord. Yes, possibly. It certainly can't be ruled out, and the experience of this litigation shows that the parties at least have a tendency to pursue matters as far as they can. And we do say that our concerns in that regard are particularly relevant in view of First of all, concerns about any delay in meeting the funding arrangements and indemnity, and also in view of the financial position of the bankruptcy estate. And to develop the point that Lord Justice Lewison mentioned earlier, these estates are, as it was put in evidence before the judge, underwater, in the sense that the available assets are significantly outweighed by costs and expenses, such that there is a very significant shortfall of assets and funds in the bankruptcy estates to meet fees and expenses. And Ms. Kicks said that in terms, and it's paragraph 49 of her first witness statement. Now, that was considered before the judge in terms of standing. Did that prevent the creditors, so the first two respondents, Ms. Bream and Patley Wood, from having standing to apply under 303? And at least in terms of standing, the judge said there was no certainty that substantial outstanding fees and costs would be allowed in the sum estimated, or anything like it, such that trustees' remuneration couldn't prevent creditors from having an interest sufficient to apply under 303. But what we say on that, Lord, my lady, is this, that apart from the question of standing, the outstanding level of fees and costs is relevant to the question of how likely it is that the proposed course of action will lead to any return to creditors, and therefore whether it is of practical benefit to the bankruptcy estates. And as such, that was a material factor in the trustee's decision as to whether or not to apply to join the eviction proceeding. And as I've indicated, Ms. Kicks made clear in her witness statement that that was a factor in the trustee's decision not to make an application to join. Can I just show the court what the evidence shows on that? And this is in the core bundle. And I start with the progress reports. And this is core bundle, tab 7. We start at page 187. This is the progress report, just to show you where this starts. This is the progress report in respect of Mrs. Brake's bankruptcy. It starts at 186, and you'll see this is to the 29th of July 22. And if one goes on to 187, what one sees is funds in the insolvency services account, 66,700 odd. So that's Mrs. Brake. The figure for Mr. Brake is at page 200. The sum in the insolvency service account is 24,200 odd. So that across the two gives a total of...
Could you give me the second page reference?
Page 200, my lord.
Thank you.
So across the two bankruptcies, that gives a total of £90,942 odd. And in addition to those sums represented by the insolvency services account, there's an additional sum in realisations of 56,237 odd. And that one can see that at page 188. And that is a figure which applies, as appears at the top, applies to both bankruptcies. That's Mr. and Mrs. Brake. So that's from realisations and funding. So there's 56,000 odd there. So if one adds those figures together, one comes to a total of £147,180 odd in terms of assets. And if one then goes to start with legal fees, outstanding legal fees, if one goes to page 195, one sees outstanding legal fees. Well, this is outstanding expenses, the vast bulk of which are legal fees. But outstanding expenses of £80,487 odd. And that again is made clear in the line underneath the table that that figure relates to both Mr. and Mrs. Brake.
Yeah.
So that's outstanding expenses. And then if one goes to time costs, well, the first, this is the figure that I think your lordship had picked up, which is the figure in respect of Mr. Swift. Well, where one gets that figure is the first witness statement of Miss Kicks, and this is in core bundle, divider 8, page 248, paragraph 30. And it's the final sentence of paragraph 30. There are unbilled time costs in respect of the period July 15 to June 19 of approximately £500,000 plus VAT. So that's the previous trustees in bankruptcies, unbilled time costs. If one then looks at the current trustee in bankruptcies, one goes back to the progress reports that we were looking at, page 193 of the core bundle. This is Mrs. Brake's bankruptcy, and one sees the figure, carry forward time in the middle of the page, £83,200 odd. And the figure for Mr. Brake is at page 206.
206.
206, my lord, yes. And that figure is £106,392 odd, again in the middle of the page at 206.
They've got just shy of £600,000.
Yeah. Well, my lord, yes, if the total current trustees' unbilled, unmet time costs are just short of 190,000, that would be 189 odd. And then Mr. Swift's are 500. And then if one adds on the unpaid expenses, one is looking at, by my calculations, somewhere in the region of £836,000 odd, as against assets of £147,000 odd. So, my Lord, my Lady, on the basis of that evidence, we submit that the trustees were perfectly justified in reaching the view that there was no realistic prospect of monetising the cottage for the benefit of creditors, as the judge put it. And given the level of outstanding fees and time costs, there is, and this was the trustees' view, there was no realistic prospect of any substantive benefit accruing to creditors from the proposed course, as Miss Kicks had made clear in her witness statement. Or, to put it another way, that was not an unreasonable or irrational view for the trustees to have taken. And so in the circumstances, it is our submission that the judge was wrong to dismiss the trustees' concerns about becoming involved in time-consuming litigation, which wouldn't realistically achieve a better outcome for creditors, as absurd or perverse. Those concerns, in our submission, were entirely reasonable and rational.
But it is a slightly odd situation, isn't it? Because the trustees' proper remuneration, maybe have to be assessed by a court at some point, is payable as an expense of the insolvency and priority to creditors. Where you've got an insolvent estate like this one, where the trustees take the view that there's no real prospect of this litigation producing a benefit to creditors, and they may even take the view that they're not going to get paid in full, which they do. In a sense, they're just pursuing their own interests, aren't they, in deciding whether or not to join this litigation. Because whatever they get out of it is going to go to them, primarily, to pay the fees.
Yes, it's certainly in terms of fees it would, my lord, in that situation. Yes, it would. But my lord, certainly we would say on the evidence here that the trustees were perfectly entitled to reach the view that pursuing these, getting involved in these proceedings and pursuing them on the basis of the arrangements that they were directed, that were directed, there's no realistic prospect of there being a return to the creditors.
How does that affect, if at all, the test that one applies? If it be the case that trustees take the view, well, the only people who are going to benefit from this in any sense at all are us, personally, because we might get a bit more of our fees paid, and we choose not to do it. Does that affect the test?
Well, one might say one can't criticise the trust. If the trustees in that kind of situation take the view that, well, we're not going to pursue these proceedings, even though pursuit might in fact mean that a larger portion of our fees got paid. In my submission, it would be even harder to criticise the trustees in respect of a decision not to get involved, where they have decided not to.
Yeah.
So I would say that it is relevant in the sense of when one is considering perversity. Is this a decision that is so unreasonable or irrational that no trustee would have come to it? The trustees in those circumstances would certainly be having regard to the interests of the creditors of the estate, and they'd be exercising their discretion in a perfectly reasonable way.
Yeah.
Well, the second point we rely on in this ground concerns the arrangements in relation to funding and indemnity, because as we've seen, as well as referring to encouraging comments from this court as forming part of his reasoning, the judge said the trustees had funding and indemnities. And of course, as you've seen, that funding was in the form of an undertaking to the court by Chedington to pay the trustees reasonable costs and expenses. And the indemnity was in the form of an undertaking to the court to indemnify the trustees in respect of any adverse costs. As to the concerns that had been expressed by the trustees about the funding arrangements and the indemnity, the judge simply said, and this is paragraph 52 of his judgment, that those concerns had also been addressed, and he referred to the correspondence. But what we say on that is that given the range of potential views about what is or isn't reasonable, it's an entirely realistic possibility that there will be disagreements about whether the steps which the appellants consider appropriate in order to comply with the order and the costs of taking those steps are reasonable. And any such disagreements will lead to, potentially, to further time-consuming and potentially costly disputes. And in fact, what we do say is that's exactly what's happened since the making of the order. And with disagreements about whether it's reasonable for the trustees to incur certain costs. And it was only on Tuesday of this week that we had the first offer to pay a specified sum on account of the costs incurred by trustees in complying with the order. And that's more than 8 months after the order was made. And in terms, my lord, that order was couched as being entirely without prejudice to Chedington's right to say that the costs were still unreasonably incurred, so there was a risk of clawback. Well, and we say it's not an adequate answer to that concern to say that any disputes can be resolved on an application to the judge, whether, as we anticipated it, as an application for directions, or whether, as Mullen and Friends says, well, it's not directions, it's actually litigation between the trustees and Chedington. In a sense, if it's litigation, that's even worse from the trustees' perspective, because that would not only risk involving the trustees in yet further litigation, that litigation would presumably be, they would be at risk as to costs, their own costs, whereas at least if they were applying for directions and did so reasonably, then they would, one would have thought, be the beneficiaries of an order that the costs of that application would be met from the estates. And of course, one has to bear in mind in this case that this
that's not realistic. There isn't an estate.
Well, exactly, Margaret. Exactly, and that's a risk that the trustees are exposed to through this mechanism, because there are no sufficient assets in the estate. So they're effectively at risk of having to do further work and run up further costs, which they have no realistic prospect of meeting from the estate. So in those circumstances, we do say that the judge was wrong simply to dismiss our concerns about the funding and indemnity arrangements.
But where does the judge address the insolvency of the estate?
Well, he deals with it in the context of, if one looks at paragraph 12, he talks about proofs of debt. And as to assets, he quotes Ms. Kicks in paragraph 13. And then he goes on to deal with this in the context of standing.
Yeah.
In 28. Well, in 27, he talks about more money will come into the estate if the cottage is monetised. And what he says in 28, and this is in the context of considering standing, he says the trustees say there are large unbilled costs, which mean the bankruptcy estate substantially underwater. And his position is that, well, those are just an estimate, they're not liquidated. And so he says there's no certainty that any outstanding fees and costs will be allowed in the sum estimated or anything like it. Now, I entirely accept, my lord, that of course, in saying that there are costs, unbilled time costs and expenses, say in the region of £836,000, it doesn't necessarily follow that that precise sum is that all of that is going to be allowed. But what I do say is that when one looks at this realistically, when one's looking at assets in the region of £100,000, are those costs going to be reduced to such an extent that there is a realistic prospect of money being available for the creditors? And in my submission, the answer to that is no. That was certainly the view that the trustees took at the time, and we say it certainly wasn't unreasonable for them to have reached that view. Lord, my lady, our third point on our first ground of appeal ties in with our second ground, which relates to this question of independence. And if I may, I'll come to that and address that together. Lord, we do say that the judge was wrong to dismiss our concerns that our independence was at risk and would be seen to be at risk from the arrangements which were ordered. Lord, the judge dealt with this very briefly. He dismissed our concerns about risks to independence from the arrangement very shortly. He simply said they were simply absurd. Those are the words, simply absurd. And that's paragraph 54 of his judgment.
Paragraph
54. Page 55.
Yeah.
They were simply absurd. And he said, trustees in bankruptcy and other office holders accept funding from third parties every day without compromising their independence. Now, my lady, the starting point in our submission is that trustees in bankruptcy are independent, and it is vital to the proper functioning of the bankruptcy system. Not only that they are independent, but that they are also seen to be independent. I don't imagine that that proposition is contentious, but we've included in the authorities bundle an extract from Lightman and Moss on administrators and receivers. My lady, that's at tab 21 of the authorities bundle. Obviously, this passage is concerned with administrators, but in our submission, exactly the same reasoning applies to trustees.
Sorry, which tab?
Tab 21, my lord. Page 436.
I mean, the judge is right to say it's the trustee's job not to be neutral as between
yes.
a bankrupt and a creditor.
Absolutely.
He's right about that.
Quite.
Yeah.
Well, and you'll see I just invite you to read the passage there. It's the first three sentences.
Yeah.
1207.
1207.
Must be seen to be independent.
Exactly.
And partial. Yeah.
Yes. And of course, the trustees are vested with a wide range of statutory powers and privileges in order to enable them to discharge their statutory function under Section 305 of the 86 Act of getting in, realising and distributing the bankrupt estate. But as has been made clear in the authorities, trustees aren't vested with those powers in order to enable them to act as Mr. Justice Lightman put it, as a hired gun. Whereby those powers are used for the benefit of third parties rather than for the benefit of, or rather the interests of creditors as a whole. And we refer to two authorities for that proposition. The first is the case of and that is the decision of Mr. Justice Lightman, and the second is Bukhari, and I'll read a decision of the Court of Appeal and a passage in the judgment of Lord Justice Robert Walker. So, my lady, I'll return to those and say a bit more briefly about those in due course. Well, the concerns that the trustees had and have about independence and the perception of independence in this case arise on two levels. The first is one of practical reality, and the second is one of principle. And turning first, if I may, to practical reality, in this case, of course, the funding is to be provided by Chedington. And the trustees had concerns and have concerns that in the event that Chedington expresses a view that a particular course of action which the appellants consider to be necessary or appropriate isn't reasonable, or that the costs to be or are actually incurred in such a court are not reasonable, then given the absence of any other source of funding in the bankruptcy estates, the trustees are subject to a degree of practical control of Chedington in the conduct of the litigation. My lady, we refer in our note in paragraphs 10 to 12 to one example of that, which concerned the May directions hearing, where, the way we put it, Chedington would no doubt take objection to this, but we took the view that Chedington was taking an aggressive stance that the trustees had to seek a final determination of the joinder application at that directions hearing in May, and if we didn't do that, then there would be an argument about whether or not we were covered under the indemnity or not. So we do say Chedington holds the purse strings under the current arrangement, and it will inevitably have a say over what level of solicitors and counsel the appellants should instruct, how much work they may reasonably undertake, and on what matters. And indeed, that's precisely what's happened since the hearing, my lord, my lady. Chedington in December indicated disagreed with the level of counsel that was that the trustees intended to instruct, saying that they didn't consider it reasonable for Ellen from Miss Page to be instructed along with Mr. Calland, and disputed the reasonableness of the estimated costs. And even then, even though the view was expressed that Mr. Calland's estimated costs for preparing the submissions were reasonable, prima facie reasonable was how it was put, nothing was paid. As I say, the first specific offer of a payment that we've had was on Tuesday of this week. So Chedington holds the purse strings, and we do say that in looking at the matter practically, certainly as a matter of the trustees' concerns, they were concerned that that puts them subject to a level of practical control by Chedington in terms of the conduct of the litigation. Well, the second point is, well, just to finish off on that, applying back to the court for directions or to resolve those issues is no answer in our submission, particularly in the context of bankruptcy estates where there are no funds realistically available. Our second objection, though, is as a matter of principle. But we do submit that in any event, the order made by the judge was wrong as a matter of principle. And the concern of the trustees in this case was and is that the arrangement that they were asked to agree to, and on the basis of which the judge has directed them to proceed, is only possible because of funding as an indemnity being provided by a third party, Chedington, which isn't a creditor of the bankruptcy estates, but which is a party to the proceedings in which the application is to be made, and which seeks to achieve through the use of the office and powers of the trustees what it can't achieve through the exercise of its own rights and powers. And
is that in principle objectionable? I mean, what about Eden Gate, where the office holder sold a cause of action to a litigation funder?
Well, my lord, the view then, I think, the position then would be, well, would this course of action result or possibly result in any real benefit to the creditors?
That's a different question.
Yes.
That's a different question. I mean, suppose that, taking figures out of the air, suppose that Chedington had thought to itself, well, if the trustees in bankruptcy pay £50,000 in costs to make this application and oppose the relief the breaks are seeking, well, we think that's a reason, that would be reasonable. So why don't we offer them £50,000 for their cause of action instead?
Yes.
I mean, that wouldn't compromise, or would it compromise the trustee in bankruptcy's independence? They have a cause of action which may be worth something, it may not be worth anything at all because of the challenge to Mr. Swift's arrangements, but that would be a way of monetising not the cottage but the cause of action.
Yes, well, the position might be slightly different, my lord, because in the two situations, because one, of course, involves a sale, and so the trustee is after the sale has been completed, the trustee is no longer involved.
Right.
But in this case, that isn't what is happening. The trustee is to be involved, and it's the trustee's powers that are being used through the arrangement. And so what I would say on that, in my submission, is that would be improper and compromise the independence. I can quite see that in a sale, where one realises a sum for the cause of action or for an asset, and the trustee that thereafter has no involvement. The position might be different.
Yeah.
But here, it's important that the trustee remains involved. This is being done through the continuing use of the trustee's office.
And you say here, therefore, that it's a manipulation of the trustees and the use of their powers.
Yes, well, they do. And because what Chedington is seeking to achieve through its funding is the use of the trustee's powers to obtain what, as I say, through its own powers, it couldn't achieve in the eviction proceedings. In other words, it continues to enjoy possession of the cottage in return for a licence fee. Well, the effect, my lady, the effect of the order in our submission is that the trustees, on the basis of funding being provided by a third party, are being directed to use their office and the powers that go with it to seek an order which is in the interests of that third party to obtain, but which it can't obtain through the exercise of its own rights and powers. And indeed, it's right to note that the breaks and their submissions on the consequentials in the eviction proceedings set out a passage from Chedington's skeleton argument at trial in which it accepted that if the breaks were successful, they would be entitled to a possession order, and that's core bundle 8179.
Yes.
So
So
now,
that remained common ground on the substantive hearing of the appeal
Yeah.
and the directions hearing.
yeah, indeed, my lord. But now that Chedington seeks to avoid the practical consequence of that by the arrangements which it applied to the judge to endorse on the 303 application.
Well, can I just ask about that? Because, as you say, that's the position at law. But, I mean, as you pointed out, the whole ratio of this court in its judgment in October was that what had gone wrong was the use of the self-help remedy rather than an appropriate application being made to the court. And so, why is not one answer to the objection that you're raising on the question of principle? I take the point that practicality is another matter. That really this is something that could have been done at an earlier stage, and what's wrong with doing it at a later stage? If you see what I mean.
Yes. Well, my lord, again, that would involve the trustees having, in my submission, that would involve the trustees in having to take a view as to whether or not, at whatever stage, even at an earlier stage, whether or not that was an appropriate use of their statutory powers to seek the relief in terms of an order for possession.
Right. So just teasing that out a little bit. I mean, of course, it's not quite as simple as a mere passage of time and passage of litigation, because, of course, we have to wind back to the point where Mr. Swift was in office. So, as I understand it, your submission is that on the question of principle, what you're saying is that yes, Mr. Swift could have applied for possession under Section 14 of Talata, but that would have been a decision for him to make as an independent trustee, exercising his judgment in the circumstances that as they then pertain.
Yes.
Yeah.
I would. And without in any way taking sides between the Brakes and Chedington on this, in our submission, the trustees were entirely justified in having concerns about the effect of such an arrangement on their independence and also on the perception of their independence. And in our submission, there's nothing absurd or perverse about those concerns. And indeed, I do say this, these trustees are very experienced trustees in bankruptcy, as appears from Ms. Kicks's witness statement. And it is striking in my submission that they were concerned about the effect that this proposed arrangement might have, both on independence and perception of independence. It was something that didn't appear to them to be something that could simply be dismissed in the way that the judge dismissed it as simply absurd. And the two authorities that we refer to are and Bukhari. And perhaps just very briefly to look at those. Is at page, is at divider 6, the authorities bundle. It's a short report, a decision of Mr. Justice Lightman. Page 97 of the authorities bundle. And in this case, the trustee was offered by the Building Society, by Bradford and Bingley, a fee and an indemnity to use his powers to apply for an order for sale of a property over which the society, held a charge. Now, interestingly, in this case, the society could have used its own powers to apply for an order for sale, but it didn't want to do that. The judge inferred that was because it appeared that it wanted to avoid any unwelcome publicity from doing that. And so to avoid that, it offered the trustee in bankruptcy a fee and indemnity to use his powers to apply for a sale, which he did. And Mr. Justice Lightman said that he regarded that procedure as an abuse of process. And one can see in the report, page 98 of the bundle, one sees the arrangement by the letter E. The society entered into an arrangement with the trustee for the trustee to exercise his power to bring the proceedings, offering the trustee as inducements, as well, no doubt, as a fee and indemnities to costs. And then he makes the point below F that actually none of the realisations from realisation from the equity in the property will form part of the bankrupt's estate because the amount owing to the secured creditor was greater than the value of the interest in the property. And over the page at 99, just by letter G, is where the judge expresses his concern about the arrangement. And he expresses the view that he has the gravest concerns of the course adopted by the trustee. Trustee is not vested with the powers and privileges of his office so as to enable himself to act in engagement as a hired gun. His duty is to exercise his powers and privileges for the benefit of the creditors for whom he is appointed as a trustee. Then the society should not be allowed to seek to save its name, face or feelings by buying the services of the trustee in this way. In fact, although he disapproved of the procedure that was involved, because it was accepted that the society would have equally been entitled to an order for sale and would have made no difference, he proceeded to not to...
But he regarded it as an abusive process.
Yes, yes, yeah. And the other authority is Bukhari, which is behind the next tab 7 in the authorities bundle. And the issue in this case was one about liability for costs, and in particular priority of order for payment from proceeds of a sale of a family home. But it's relevant for present purposes because of the arrangement between the trustee and a creditor, again under which the trustee in that case agreed to apply for an order for possession and sale. And one can pick it up, I think, because it's just that arrangement rather than the rest of the case. At one can see the arrangement at page 159, the report, page 103 of the authorities bundle.
Yes.
And one sees the arrangement. There was to be a fee, and there was to be an indemnity. I entirely accept that the arrangement in this case doesn't have provisions such as featured in clauses 4 and 5 in that case. But again, what that case did involve, and which drew criticism from Lord Justice Rob Walker, was a particular creditor effectively procuring the trustee in bankruptcy to use his powers through funding and indemnity to apply for an order for possession and sale of a property.
Yeah.
And so we do say that at the very least there are concerns on the part of the trustees, legitimate concerns we submit, about whether or not it is said that we are acting as a hired gun in the Bukhari cases. We'll Lord Lady, there is also this, in the context of independence and duties of the trustees. It's right to note that because of those concerns, the trustees, again having taken advice, they were of the view, subsequent to the making of the order, that consistent with their position and a duty of candour, that they should at least raise concerns they had about whether or not they as trustees were entitled to an order of possession with this court when they made submissions on the consequential. And of course, that was the reason for going back before the judge in December. And the judge said, you can't put those submissions before the Court of Appeal. And that's the order that appears in, it's in the supplemental. It's in the supplemental bundle. Supplemental page 131A.
Page
131A, my lady.
Thank you.
So the trustees, the court's probably appreciated, the trustees, having taken advice after the order of Judge Matthews in November, took advice. Concerns were raised about whether or not they actually were entitled to an order of possession. So they went back before the judge on an application that was framed as in the first instance as an application for directions about whether or not they could put draft submissions that were put before the judge, whether they could put those submissions before the court. And the order that was made, as you'll see at paragraph 3, that 3.1, the trustees shall not submit to the Court of Appeal the draft submissions appended to the application notice, should clearly assert a right to the beneficial interest in the cottage. And then in 3, may refer to their claim to the beneficial interest depending on issues that are raised and to be determined in the insolvency proceedings. But if they do so, they should state that for the purposes of the eviction appeal, they hold the beneficial interest until the contrary is established in the insolvency proceedings. So the trustees were, notwithstanding the concerns that they had, notwithstanding what they thought was the correct approach in terms of discharging duty to this court and making an application, they were specifically directed not to put those submissions before this court, subject to the point in 3 and 4 of that order. Again, in my submission, my lady, that is a somewhat unprecedented step.
Seems extraordinary for a court to order a party as to what to submit to another court.
Well, my lord, indeed. That would be my submission exactly. I was being relatively mild and modest in the way I put it, but it is. We've seen that a trustee, for any party, we would say that would be surprising, but we would say it is particularly surprising in the context of trustees in bankruptcy, who, as we saw from the passage in Lightman and Moss, are officers of the court. They have a duty of candour. They took the view, having taken advice, that they might ultimately, the concerns might fall away ultimately, but there were real concerns about whether they were entitled to the relief that they were to ask this court to make, and at the very least, they felt that it was appropriate that they should put those concerns before this court, for this court to decide them. And the effect of that order of Judge Matthews is that you're not even allowed to put them before the court. And so we say that is in our submission, that would be an unwarranted interference with the independence of the trustees. The view that they had reached in the exercise of their discharge of their functions as to what submissions they should be making to this court. Just to go back to the independence point about funding, the point that the judge made was that, well, IPs accept third-party funding all the time. But in our submission, that doesn't meet the point in this case, Lord, my lady, because we do say there's a substantial difference between a case where, say, a creditor offers a trustee funding to pursue particular court proceedings with the hope that there may be a return to creditors as a result of a successful outcome in those proceedings. There's a difference between that and a case where the third party offers trustee funding to join proceedings to which it's a party, so that the trustee can adopt a position and use his or her powers in a way which promotes that third party's interests in those proceedings. And as I've said before, interests which it can't promote through the use of its own powers. We do say that that is much more akin to the hired gun type analysis that we've seen from Mr. Justice Lightman.
We've got three potential situations, haven't you? You've got a trustee who has a claim and accepts funding from a creditor to pursue that claim, because the creditor takes the view that it's going to result in a dividend or increased dividend for the estate. You've got a case where the trustee has a claim and sells it to whoever's going to pay him the most money for it, and then a third party will advance the claim himself, but it'll be the trustee's claim. And you've got this situation where the third party doesn't choose to buy the claim, but wants to use the trustee to advance the claim with funding, as we know about.
Indeed. And well, we do submit that that latter category of case falls into the category of hired gun.
Yeah.
As to the fact that the application was made not only by Chedington, but also by Mrs. Bream and by Patley Wood, who are creditors in the bankruptcy because they've submitted proofs of debt. Our submission on that is this: that the proposals are funded by Chedington, both as to the funding, the indemnity, and also the proposed licence fee. Chedington isn't a creditor, and this arrangement is only possible through the funding that is being provided by the non-creditor, and its interest in doing that is trying to obtain an order in the eviction proceedings whose effect is to maintain the current position. And as to potentially putting money into the bankruptcy estates or monetising the cottage for the benefit of the estates, as the judge put it, given the level of costs and expenses already incurred, as we've seen, it is in our submission.
But that's just going back to your first point, whereas here you're on the question of principle.
Yes, that's right. I'm just trying to deal with at this point now, wrapping up the other points that were made in response to our submissions about independence, one of which is, well, this isn't just Chedington, there are creditors who are also applicants as well. So we do say, though, for those reasons, that the fact that this application was joined by two of the creditors doesn't fundamentally change the nature of the position. And my learned friend says, well, these directions simply reflect and reinforce the trustee's basic duty to take steps to obtain a proper price for assets in the bankruptcy estate. Well, the first point to make about that in my submission is that that duty, which arises from the terms of Section 305 of the Insolvency Act, expressly provides that in carrying out that function, the trustees are to use their own discretion. That's something that the trustees did in this case. And in our submission, that exercise of discretion was certainly not perverse. They were of the view that the proposed course of action involved not only a threat to their independence, but wouldn't achieve any material benefit for creditors. So, my lady, subject to any points that you may have, for those reasons, we submit that the judge was wrong to find that the trustees were perverse in deciding not to make an application to join, and the appeal should be allowed accordingly.
Thank you, Mr. Whittle. Yes, Mr. Day.
My lord, my lady, this appeal should be dismissed. It raises no point of law, and the grounds of appeal do not contend otherwise. And instead it mounts a misconceived challenge.
Could you speak up a bit?
Sorry, I'm sorry, my lord. It raises no point of law, this appeal, and the grounds of appeal do not contend otherwise. So I'll come back to this idea of a point of principle in a moment. And instead this appeal mounts a misconceived challenge to the judge's evaluation of the evidence and his application of the law to the facts. And in bringing this appeal, the trustees should not be acting in their own interests, but rather in the interests of creditors, who so far have yet to receive a penny in dividend from these bankruptcies. No creditors oppose...
So you say they can't take into account their own interests. So you say they can't have regard to the fact that they are not going to get paid.
Correct, my lord. They're here as fiduciaries.
Right.
And they are to act in the best interests of creditors. Now, my Lord Justice Lewison raised the question about the costs and the direction that costs not be reimbursed from the estate, I accept there could be an appeal from that costs order insofar as there was a direction that the trustees were not to recoup those costs from the estate, because then they're interested in their own capacity. But in terms of the appeal as trustees in bankruptcy, they are fiduciaries for the creditors unless and until there's a surplus in the estate, in which case they become fiduciaries in respect of that surplus to the bankrupts. No creditors opposed the directions below. No creditors support this appeal. No creditors, so far as we are aware, have ever expressed any concern about the funding structure at the heart of this appeal. And no creditors were told that the trustees were proposing to run up expenses and legal costs of nearly £210,000 in challenging these directions. And that's, in my submission, extraordinary, given the submissions that you've just heard from my learned friend about these estates being underwater even before these directions were sought. And just so you have it, inclusive of VAT, the trustees spent £30,000 at first instance challenging these directions, and nearly £190,000 on this appeal. And it's very difficult to understand how this appeal, with those associated costs, which the trustees will presumably try to charge to the bankruptcy estate, could possibly be in the interests of creditors. The only creditors who
But if they succeed in the appeal, they might try and charge you.
Well, there is that, my lord, and I come back to my first point, which is that they're not entitled to be here for self-interested reasons. They're here to represent the interests of creditors and to appeal an order which was sought, as I'll show you in a moment, to obtain some reassurance, to spend 6 times on the appeal what was spent at first instance, and presumably to try and charge that back to the estate in due course, cannot possibly be in the interests of creditors. And the only creditors who have stated any view on these directions at all are the first and second respondents, who represent 60% of the grieving creditors in the appeal. The judge found below that those respondents had a clear financial interest as creditors in the proposed directions, because that would potentially put money back into the bankruptcy estates. That's paragraph 32 of the judgment, core bundled, tab 5, page 49. And on that basis, the judge held that the respondent had a legitimate interest in the directions sought, and so had standing to seek those directions. And there is no appeal from that part of the decision below. Indeed, it is now common ground that the purpose of these directions is to seek a financial return for the benefit of the bankruptcy estates. And I ask you to go to the supplementary bundle, tab 73. I believe it's 73.
Yeah.
It might be, my apologies, I think it might be 72. It's page 291 of the supplementary bundle. It's one of the more recent updates.
Page 291.
291, you'll find the first witness statement of the first appellant in the eviction proceedings. And can I ask you to go over to page 292? And halfway through paragraph 9, you'll see a sentence beginning the purpose behind this order, which is referring to the directions.
Yes.
Can I ask you to read from there to the bottom of the page?
But isn't this what the judge ordered them to do?
Well, he ordered them to join the eviction proceedings.
Well, and to put forward a particular case and to support it.
He did. He didn't say that they had to say those words. And in my submission, the starting point, in terms of what has been appealed, is that the trustees are seeking to set aside directions, the purpose of which is to generate a return for the bankruptcy estates, and in which the majority creditors...
So you say that in complying with the judge's order, the trustees are deemed to have conceded the correctness of the premise upon which the order is made, even though they're challenging that in this court?
No, my lord, I'm not going that far. I'm seeking to identify the starting point for this appeal. And I say in circumstances where there's no appeal from standing, and given the witness statement that has been served in the eviction proceedings,
Well,
when one is
yes,
asking...
but you're right, Mr. Day. That is the purpose of the direction, is to generate a return for the insolvent bankrupt estate,
my lord, yes.
which on the figures is unlikely to produce any return to creditors.
I'll come to the figures in due course. And you're right, this is a modest proposition. I'm just seeking to identify what the purpose of the directions are, which is to generate a return for the bankruptcy estates in which the majority creditors have a legitimate interest. And there's no appeal from that. That's as far as this submission is going. Now, further, no distinction has or could be drawn in this context between the legitimate interests of the respondents as the majority creditors and the interests of creditors as a whole and as a class, and that is because there is no fracturing of the class interest by the directions that have been sought and obtained. They do not advantage my clients, the first two respondents, over any other proving creditor in the bankruptcy estates. So if directions result in money coming into the bankruptcy estate, and subject of course to the expenses point, which I'll come back to, all proving creditors will share in those proceeds on a pari passu basis. That's why there's no fracturing of the class interest. And so it follows that it's not just the majority creditors who have a legitimate interest in these directions, it's in the interest of the proving creditors as a whole and as a class that these directions remain in place and not be set aside. And in my submission, that makes this appeal improper and irregular, because as I've already alluded to, as fiduciaries for the creditors, the trustees are not entitled to be here for self-interested reasons. They have a duty to act in the interests of creditors, not against them. But by being here, the trustees are acting against the legitimate interests of creditors. And that complaint is made and reinforced by the related point made by the judge below when refusing permission to appeal. I think my learned friend took you there already, but just to go back there briefly, it's core bundle, tab 6, page 71. Paragraphs 56 and 57 of the consequentials judgment, with some opening remarks about refusing, before going on to refuse permission to appeal. Now, we respectfully adopt that analysis, including the analogy with the principle about trustee appeals under private trusts. There's no need to go there, before you'll note Londonderry settlement is authorities tab 2, and the relevant passages of pages 23 to 24 of the authorities bundle. And the position is well summarised in Underhill and Hayton. We can go there briefly. That's authorities tab 24. First page, paragraph 85, spot 23, the last sentence, where trustees have sought guidance from the court so as to be protected by the court's order, then generally it's not for them to appeal, that should be done for beneficiaries, and then there's a footnote to Londonderry settlement, and then again over the page, paragraph 89, spot 62. says trustees and beneficiaries are able in appropriate cases to seek authoritative guidance from the High Court at the expense of the trust fund. However, once such guidance has been obtained, then in the absence of some special circumstances, e.g. difficulties arising from that decision itself, parties have the authoritative guidance they need. The fact they do not like it will not justify the costs of the appeal. And we say those observations are particularly appropriate in this case, given the costs that have been run up by this appeal, as I've already mentioned.
Yeah, but I can't remember exactly what I said, but footnote 3 into 89.63 is to a decision of mine, Airways Pension Trustee Scheme. Trustees. And all I can remember was that I had to go over all of this ground in that decision. I can't remember what I decided or why, but I do know I had to go over all of these authorities at that.
My Lord, that's very helpful. We'll have a look at that authority in the short adjournment and provide copies if that would be helpful.
It may not be, I don't recall, but
it's certainly worth checking. Now, we accept that the Londonderry principle doesn't apply directly because the trustees in bankruptcy are not private trustees, but we say that the position is clearly analogous and should be extended because the underlying point is the same. Like a private trustee who must act in the interests of beneficiaries, the trustees in bankruptcy should not pursue this litigation for self-interested reasons, costs, reputation, whatever it may be, but only act in the interests of creditors. So if the trustees argued the directions below, at least in part because they considered that the court needed to give guidance on the issue, once that guidance has been given, it's for the creditors to pursue any appeal, not the trustees, on their own initiative, because the trustees have the protection of the directions given below. And we say the current appeal engages the Londonderry principle precisely because of the position adopted by the trustees at the hearing below. If I can show you two brief references.
yeah, just before you go on, could you help me on this? Because what's the significance of this? Because I can understand it as a cost submission, because I mean that was the issue in the Airways Pension Trustees. I mean, in fact, it was looking at protective costs for an appeal. But the argument was all about the costs. It wasn't about, and this is why I'm asking you the question, about, as it were, standing to bring an appeal. Is it your submission that the present appeal should be struck out because the trustees have got no standing to bring it?
My Lord, yes, that's the gist of my submission, that it should be
Or was this a point that was made to Lord Justice Newey?
No, I don't think it was.
Because there might be a reason for not granting permission. But permission has been granted.
I can see that point, my Lord. We've taken this on the substantive appeal.
Yeah,
Sometimes
and
standing points
as it
are-
happens in Londonderry settlement, the trustees did appeal and the appeal was allowed.
It was, but the majority expressed grave concerns about the approach of the trustees in that case, and they said it was a procedural irregularity. They went on to deal with the substance of the appeal, but in my submission, the principle from that case is clear. And we say as a starting point, our primary submission is that this appeal should be dismissed on the basis of procedural irregularity because this appeal is not in the interests of creditors.
So, well, wait a minute. That would mean, in effect, setting aside the grant of permission to appeal.
My Lord, no, that's not how I'm putting it. I've taken this point on the substantive appeal, but in my submission, and I'm not asking for a strikeout, as my Lord.
What are you asking?
Put it, asking you to dismiss the appeal on the basis of procedural irregularity.
So you don't say Lord Justice Newey was wrong to give permission.
Well, he can't be because I didn't take that point in the 3-page statement.
Well, that would have been the place to take it.
Well, my Lord, in my submission, it's as appropriate to take it now as at the stage of permission to appeal.
But can you help me on this? I mean, you said twice that you're relying upon procedural irregularity, and I understand the concept, but I'm struggling to understand the relevance of it to the present case because the present appeal has been brought in entirely in accordance with the applicable procedural rules. They filed their appellant's notice in due time, they applied to the court for permission, they obtained permission, etc., etc., etc. So from a purely procedural perspective, all rules have been complied with. So how, therefore, is it procedurally irregular?
My Lord, you're quite right. I'm using that phrase because that's the phrase that appears in Londonderry settlement. I mean, you don't have to use that label. You can just say this appeal is not in the interests of creditors. And that's a reason to dismiss it without getting to the substance of it. But I'm using that phrase simply because that's the phrase that appears in the leading case. I agree, I'm not contending that the trustees of bankruptcy have done something that's not in accordance with CPR 52, for example. It's a different type of irregularity which arises because these are not appellants who can appear here self-interestedly. They're here because they're fiduciaries. That's the capacity in which they appear. And so the starting point for this appeal is to ask whether this is, given the majority beneficiaries, if I can put it that way, are the respondents to the appeal, whether this appeal being brought at all is in the interests of creditors as a whole and as a class.
All right, well, that's a helpful clarification, but I'm still struggling now that you've explained more clearly how you put the point, what your answer is to the question my Lord Justice Lewison put you, because if the decision of the court in Londonderry had been to dismiss the appeal, then I would understand where you were coming from. But that wasn't the decision. The appeal was allowed. So how is this an independent basis for the appeal before us to be dismissed?
Well, my Lord, the way I put it is this: there's a statement of principle in Londonderry which is endorsed by the leading textbook on trusts and trustees. And that statement has been identified as a point of principle. Regardless of the outcome in Londonderry, it's where the court effectively said it was embarrassed, but would go on to consider the appeal nonetheless. A little bit like in re-NGD, where the court said it was abusive process, but they'd go on to hear it anyway. And I accept them.
Do you say it's an abusive process or not?
It's not an abusive process.
So it wasn't wrong to grant permission to appeal. There is no procedural irregularity in the sense that no rules have been breached.
Yes.
It's not an abusive process.
It's not an abuse of the court's process. We say it's an abuse of, if I have to go that far, I say it's an abuse of the trustee's fiduciary position, because they should have pursued this appeal only if it was in the interests of
It is an abuse of trustees' fiduciary position.
If I can put it this way, it's effectively the interlocking of the procedural process with the duties that the trustees are subject to in engaging in the litigation. The private duties to, not to the court, but to the creditors.
And therefore, we should dismiss it irrespective of its merits.
Yes.
And so you're saying once you've got directions as a trustee to do something, it's not for you to say you don't like them, you should do it. And in being here, the trustees in bankruptcy must be therefore pursuing their own willful interests rather than acting properly as fiduciaries.
My lady, yes, that's the point.
Okay.
Now, it might be different if other creditors had come forward after the directions below and said we disagree. The trustees could then appeal, but take a neutral position on the appeal, and the argument would be between the opposing creditors on either side of the court. What's irregular is that no creditors to whom the trustees owe duties have opposed these directions. And I'm repeating myself now,
So it would seem to follow from your submission that trustees are obliged to follow the directions of their creditors, regardless of any cost to the trustees that will follow. Personally.
Not regardless. I accept that the order providing that they weren't able to seek reimbursement of the cost below from the estate could be appealed, because that wouldn't be in their capacity as fiduciaries. They're interested in that themselves. But otherwise, no, they're only entitled to pursue this appeal, in my submission,
But sorry, let me rephrase my question because perhaps I wasn't clear enough in what I meant. Suppose, and I appreciate you are likely to be going on to dispute the factual hypothesis that I'm about to proceed on, but let's just take it as a hypothesis. Suppose that if the order made below stood, the consequence of that would be to leave the trustees personally out of pocket in due time. Do you say that it is still an abuse of their position to appeal?
My lord, it depends the reason why they're out of pocket, if I can put it that way. If it's they're out of pocket because of the order about reimbursement, you have my submission on that already.
Yeah.
If otherwise they're out of the pocket, we say no, they're not entitled to appeal. That's part of the rough and the smooth of being a trustee in bankruptcy. That sometimes you will run up expenses that you will not be able to recoup from the estate.
And just to follow up my lord's hypothesis, and put another hypothesis to you, let us hypothesize that the estate is £500,000 in the red, taking into account liabilities on the one side and assets on the other, and that on that basis there's not going to be any dividend to creditors. And the trustees take the view that if they embark on this course of action, the estate will end up £600,000 in the red, so the prospect of a dividend is even further away. Why is that not in the interests of creditors? To minimise the gap between the expenses of the insolvency on the one hand and the possibility of a dividend to creditors on the other.
Well, my lord, I think the starting point we say is, and I'll come on to develop this, that the trustees are under a duty to take reasonable steps to realise value from bankruptcy estates, from the assets in bankruptcy estates. And so that becomes a question, and I will develop this, about whether there were reasonable steps which the trustees could take to realise value from what was left of the assets in the bankruptcy estate. And so the hypothesis that my lord poses to me has to be considered against that duty, and I will come on to address that shortly, if I may. My lords, my lady, I was going to briefly show you two items from the supplementary bundle just to complete this point on Londonderry. It might be I can just give you the references, or you might want to have a brief look at them. The first is in the supplementary bundle at tab 33. This is a letter from Gatesley dated the 16th of November 2022. This is on the morning of the hearing below. And it's in response to a letter from my clients the previous day, asking them to take a neutral position on the directions. And at paragraph 2, the trustee says it's clearly not possible for the trustees to adopt a neutral position in relation to the application. And then at paragraph 5, they go on to say, in the event that the court determines that the trustees have acted perversely and therefore makes the direction sought by your client, as the trustees have previously confirmed, they will abide by whatever court order is made in this regard. And that point was made even more clearly in consequential submissions. If we can go, same bundle, tab 5. Page 119, it's the last page in that tab. My lords, my lady, you'll see there, in paragraph 24 it said, the trustees did not act unreasonably in resisting the application made against them. And then one line on, in particular, it was reasonable of the trustees to decline to act without the reassurance of a court order requiring them to do so. Now that the trustees have the reassurance of those directions, and they should abide by them, but far from abiding by the order made by the judge, the trustees first sought to relitigate the issue under Section 375 of the Insolvency Act, from which there was no appeal, despite the submissions of my learned friend a short time ago. And then when the Section 375 application failed, they then brought this appeal. No one could have criticised the trustees in bankruptcy had they stopped this litigation after the order made below. No criticism could have been made if they hadn't pursued an appeal, at least without a request of creditors or a body of creditors. And what underpins this appeal, we say, is not the interests of the creditors, but the interests of the trustees, in avoiding the liability for the costs below. We've touched on that already. And in seeking in some way to mitigate the judge's criticism of their conduct in the judgment below. Now, we quite understand that the trustees may not like those directions and may not like the observations made about their conduct in the judgment below, but that does not justify this appeal. They're not entitled to be here as office holders as a matter of self-interest. And for the reasons I've already given, it's in no creditor's interest for them to be here, and no creditor says otherwise. So for those reasons, we say this appeal is irregular. Perhaps they put it in terms of procedural irregularity, given the exchange I had with my Lord Justice Arnold, but certainly offends the Londonderry principle applied by analogy. And we say the appeal should be dismissed on that basis. Now, turning to the substance of the appeal, my submissions will fall under three heads. First, we say the judge was plainly right to accept my client's case when hearing the application below. Second, we say that there was ample material before the judge to support his evaluation of the position. And third, we say there is nothing in either half of the sole ground of appeal that would entitle this court to overturn the judge's evaluation of the position below. And I'll develop my submissions under those three headings. But before I do, can I make a preliminary point about the applicable threshold for an appeal of this nature and respond to my learned friend said on that? It's common ground that the judge articulated the correct legal test. That's paragraph 4 of my learned friend's skeleton argument. And so this appeal is limited to the judge's evaluation of the evidence in the application of that test, rather than on any point of law. And I address the relevant principles of paragraphs 8 to 12 of my skeleton argument. And we say it was also a point well made by the judge below when refusing permission to appeal. I can just briefly take you there. That's Core Bundle, tab 6, page 71. We've been here already. We finished at paragraph 57, and at 58 one sees the 4 grounds of appeal. Only the 4th is now pursued on this appeal, and the judge then refuses permission in respect to the 4th ground, paragraph 66 on page 73, where he explains that it was an evaluative assessment of the evidence before the court. And there, when he says, as pointed out earlier, that's a cross-reference up to paragraph 60, where the judge makes a similar point in respect of one of the grounds that are no longer pursued, and quotes what Lord Justice Baker said in an appeal where my Lord Justice Lewison and Lady Justice Asplin were sitting as well in one of the earlier Breaking Guy cases. And the same point is made...
On the other hand, it's not impossible for such appeals to succeed. Look at Brabston and Hout, where the appeal was allowed.
No, quite. I'm not saying this appeal, once you're into the substance of it, I'm not saying it's a hopeless appeal by any means, or that the threshold is set at a level which can never be reached. I'm just saying that the threshold is higher than in a more orthodox appeal where there's a point of law as issue. And we do take issue with what my learned friend said this morning, where he said, don't worry about the word plainly, don't worry about the word so. It's just a question of whether the judge was right or wrong. That's right for points of law.
But there's also a difference in an appeal court's approach, where the judge has heard oral evidence and a case where the evaluation has been conducted entirely on papers.
My Lord, yes, there's a spectrum. I accept that. Now, a similar point was made in Re Edendames, which my learned friend took you to. I won't take you we rely in particular on what Lord Justice Mayo says at paragraph 45. And it is instructive in Re Eden that the appellant, one of the appellant's arguments was that there was a point of principle in the appeal. That there was a point of principle in that the office holder should have offered the cause of action to the party then being sued by Manolay, or about to be sued by Manolay, which is an insolvency funder. Lord Justice Mayo says, no, it's not about points of principle in cases such as these. Every case will turn on the circumstances of the case. And in my respectful submission, the same approach should be taken even in respect to the arguments about points of principle in this case. Each case turns on its facts. And therefore, in terms of the function of this court, it's not to ask whether the judge was right or wrong, but whether the judge reached a conclusion which was outside the bounds within which reasonable judicial disagreement is possible. And I use that phrase, that's Lord Hodge in Activis, which I quote in my skeleton in paragraph 10. Now, I accept the bounds may differ for an appeal where it's from an effectively interlocutory application as opposed to a trial, but we still say that's the relevant threshold here. Did the judge make a decision that was beyond the bounds where judges reasonably can disagree? And for the reasons that I'll now go on to develop, we say that this appeal doesn't get anywhere near that hurdle. That brings me to the first of my three headings, why the judge was plainly right to give the directions now challenged on this appeal. And I'll take this briefly. This is, in effect, the headline points of the case made below and the case being repeated, as it were, before my lord to my lady. These directions concern the beneficial interest in West Axel Cottage, which is the last substantial asset in the bankruptcies. You have my submission already that the directions are aimed at maximising the value of the cottage for the benefits of the estates in which the first and second respondents are interested as creditors. The sale of the beneficial interest to Chedington or another third party is currently paused until resolution of the insolvency proceedings currently before the Supreme Court. But possession of the cottage pending sale is itself capable of generating value for the Breaks bankruptcy estates. And that's demonstrated by the offer made by Chedington to buy a licence at a fee of £3,000 a month once the trustees take possession of the cottage. Now, under the directions given by the judge below, the trustees aren't bound to accept that offer, but it's the only offer currently on the table, and it provides a floor in terms of the value that can be realised.
All this assumes, doesn't it, that the arrangements made by Mr. Swift were properly made,
Yes.
and in consequence, the sale to Chedington was proper,
Yes.
although the title is still in the Breaks and Mrs. Bramer.
Registered title.
So the beneficial interest has passed to Chedington because of the contract, is it not?
It's a conditional sale contract, so
And the conditions were never complied with.
the conditions weren't, because one of the conditions was that Mr. Swift would make the application to court, which in effect we're now seeking that the trustees make.
Yes, I think we were told at the appeal that there was a long stop date which had passed, so that contract was off.
I think the long stop date has passed, and there may be an argument in due course about whether.
So,
That was definitely as I understood it.
Yes.
so the sale to Chedington has gone, is it?
No, I mean the trustees haven't said that. They say they're not taking any position on the validity of that contract.
No, well they say it may not be valid at all, but if it's valid, if it was valid when it was made, and the long stop date has gone, then presumably Chedington are no longer, nobody's bound by the contract anymore. It's gone away.
Well, my lord, it may depend on whether there's been a waiver of the long stop date, and I don't think that's something we can go into on this appeal.
No.
But the position is.
I have to say there that I don't think that was a position which was taken when other matters have been before this court before. It was that there was a long stop date which had passed, and that was the end of it.
The Breaks position in the eviction appeal was the long stop date had passed, and that was the end of it. The trustees have, so far as I'm aware, and I'm happy to be corrected, have stated a position on that. And Chedington has decided not to get into that argument yet.
I was just wondering where this £3,000 a month is actually going to end up.
Well, my lord, let me deal with that. One has to consider the directions against the context of the two parallel appeals that are currently proceeding, the insolvency appeal and the eviction appeal. In the eviction appeal, parties are proceeding on the assumption that those arrangements are valid and binding. That was the approach taken by the judge in first instance. I can give the reference if that would be helpful. That's in...
No, he said that the propriety of those arrangements was a matter for the insolvency proceedings and not for him.
Yes.
So he didn't rule on it.
And there was no...
That was the position when the matter got to this court.
Correct. So the eviction proceedings in which these directions seek the intervention of the trustees proceed on the basis that those arrangements are valid and binding.
On the assumption, but of course, if it turns out that assumption is incorrect, then that will have consequences.
My lord, yes, which is why the other bit of the relevant context is, of course, the insolvency proceedings.
Yeah.
And why this licence terminates on resolution of the insolvency proceedings.
Just let me follow up I'm just trying to work out where this £3,000 is going to end up.
Yeah.
If the Supreme Court were to uphold this court and say the Brakes have standing to challenge Mr. Swift's arrangements, and if the challenge were to succeed, where does the £3,000 a month end up?
Well, my lord, the £3,000 ends up with the trustees in bankruptcy because it will be a personal obligation this is assuming that the licence is entered into, be a contractual obligation by Chedington to pay the trustees in bankruptcy for a licence to be in possession of the cottage. So that's not affected.
The liquidator of the partnership would have no claim on it?
No, and I think, although there may be arguments around the edges, I think my lord is right when the question was asked earlier, that the alternatives in the insolvency proceedings are, does the cottage vest in the bankruptcy estate, or does it vest in Mr. Swift personally? The liquidators aren't saying that they have a residual contingent beneficial interest, because that, the liquidation...
So £3,000 could end up with Mr. Swift then?
Well, no, because it's a personal obligation. The licence would be a personal obligation.
I see.
To pay the trustees in bankruptcy £3,000 for possession.
Right.
So Mr. Swift wouldn't be entitled to that. The licence is purely a creature of the contract.
Yes.
So, in other words, I was on the value to be realised from possession of the cottage. And the choice before the judge below, and the choice as it remains now, from the trustee's perspective, is that Chedington's offering that sum. The Brakes, the bankrupts, now live elsewhere and they won't generate any income or revenue for the bankruptcy estate if they take back possession of the cottage. Now, against that backdrop, and this picks up on a point I alluded to earlier, an answer to a question from my Lord Justice Lewison, the trustee's duties require to take reasonable steps to realise value from the cottage. And can I ask you to go in the authorities bundle to authorities 23, tab 23.
23?
23. Sorry, ma'am.
No, I'm sorry.
Section 305.
Section 305 and the relevant provision, which I don't know if Mr. Westwood referred to earlier, was subsection 2. Function of the trustees to get in, realise and distribute the bankruptcy estates in accordance with the following provisions. And in the carrying out of that function, the trustee is entitled, subject to those provisions, to use his own discretion. And then over the page, at 444, next to the highlighted line, the trustee has a discretion in carrying out the functions of getting in, realising and distributing the bankrupt's estate. In the management of the estate, accordingly, he can use his discretion. However, this discretion notwithstanding, it is no doubt the case that a trustee owes a duty in respect to the bankrupt's estate to take reasonable steps to to obtain a proper price for its assets. Then if we drop down after the reference to Charnley Davies, it says the obligation to take reasonable steps to obtain a proper price for assets is an obligation which the law imposes on anyone with a power, whether contractual or statutory, to sell property, and we would add there, or otherwise to realise value, which does not belong to him. And it goes on, and then just before, 4 lines up from the bottom, it says an administrator or other person in a similar position is not to be made liable because his perception is wrong unless it is unreasonable. And that, of course, is a reference to the standard that we had to meet at first instance in seeking relief under section 303. So the question before the judge, we say, was this: what reasonable steps were the trustees taking to realise the value of the cottage pending sale for the benefit of the estate? And the answer to that question is none. They chose to fold their arms and do nothing at all. That was how the judge put it below. For your reference, that's paragraph 55, core bundle tab 5, page 55. And we say there is no proper basis for challenging that evaluation of the position on this appeal. And we say further that the trustees' decision to do nothing can only be justified by reference to their duties to creditors if the court below were satisfied that there were no reasonable steps at all that could be taken to realise the possessory value of the cottage pending sale for the benefit of the estate. And we say that was not and is not this case. And in fact, as the judge noted again at paragraph 55 of the judgment, the trustees' decision to do nothing was despite offers of funding and indemnity, encouraging comments from this court, and a clear opportunity to monetise the cottage for the benefits of the estate, with at the very least the offer from Chedington for £3,000 a month. And those circumstances, we say, created a clear and straightforward footpath down which reasonable steps should have been taken for taking possession of the cottage. And the judge was right to conclude that any reasonable trustee would have gone down that footpath for 3 reasons. And I'll develop them under my second and third headings, just so you have them in outline. First, the downside risk of losing the litigation and the adverse costs being removed entirely by the indemnity offered by Chedington and embodied in the undertaking to court. Second, the reasonable costs of pursuing that litigation have been met by the offer of funding from Chedington, again embodied in the undertaking to court. And third, what was being asked of the trustees was not especially onerous. All that was being asked of the trustees was to intervene in a single ground of appeal, ground 3, in a single appeal. And I'll develop those points in more detail. But for those reasons in outline, we say the judge was obviously right to give the directions below. And that brings me to the second of my 3 headings, if I may, which is that there was ample evidence before the judge that entitled him to make a finding of perversity against the trustees. And the central point here is that the trustees gave an ever-changing series of reasons before the hearing of the application below for not intervening in the eviction proceedings. And the obvious inference from those ever-shifting justifications was that the trustees decided not to litigate against the breaks first, and then searched retrospectively for reasons that justified that decision.
So that's impugning the good faith of the trustees.
No, we say it's, I'm not putting it higher than perversity. We say it's that sort of retrospective justification is textbook perversity, that no reasonable trustee would do that. I'm not going beyond that to say fraud or bad faith. I say I don't need to for the purposes of establishing perversity. Now, we made that point in paragraph 39 of my skeleton argument, and it's also consistent with the judge's own assessment of the material before him, if we can go to the judgment in the core bundle, tab 5, page 53, and look at paragraphs 49 and 50.
Just before we get into the detail, I'm a little puzzled by this submission because the judge's approach, which I assume you support, was that he had to consider the matter as at the date of the hearing,
Yes.
not as at some earlier date.
Yes.
And I assume you support that.
We do.
Right. So why is therefore the judge not consistently with that approach required to look at the reasonableness or otherwise of the trustee's stance as at that date? What's the relevance of the historical evolution?
Because we say the judge was entitled and had to take into account everything that had preceded the run-up to the application. And he had to consider the credibility of the trustee's stated concerns about the difficulty.
Credibility? Are you attacking credibility?
Well, that's what the judge does in this judgment and in December. We support that finding, and that may be an answer or one factor to take into account in terms of where this appeal sits in that spectrum. The judge took a very dim view of the reasons being put forward by the trustees in bankruptcy.
Well, it's very rare to decide a question of credibility on the papers.
Well, what the judge says at paragraph
50?
50.
50?
Yeah, so at 49, he makes the point that my Lord Justice Arnold just picked up, which is that he says it's possible for a trustee to be perverse, not because of the original decision, but once mistakes have been corrected in maintaining that decision. That supports the submission I just made to my Lord Justice Arnold. And then at paragraph 50, what the judge finds is this: looking at the evidence and the sequence of events in the application, what I see is these trustees striving at all costs, not to have to take part in the litigation against the breakers. And having made that finding, the judge added, that is to my mind an entirely illegitimate consideration. These trustees are professional office holders, experienced in what they do, as indeed my learned friend was pains to point out on this appeal, as well as at the trustees below, and they're remunerated at professional levels to take on difficult jobs, and they chose to take on this one. And the judge returned to that point when dismissing the section 375 application. That judgment is in the authorities at
So just pause a minute. So the trustees should take into account their remuneration when deciding whether or not to take a decision, because the judge is saying they are remunerated, so that's a factor. But you say they can't take that into account when deciding what to do.
My Lord, I'm not sure that's how the judge below...
Well, what's the relevance of remuneration?
Well, it is an answer to the point being made below, and again on this appeal, to the twin set of submissions, one of which is this is all very difficult, and the other of which is we're very experienced office holders and we know what we're doing. So it's an answer to that submission being made both below. It's not, it doesn't otherwise go anywhere, in my respectful submission. Now that evaluation...
So, but can we return to the question I was asking you? Because you helpfully draw attention to this passage, and I think it is very relevant to the inquiry. So if we look at that sentence to which you drew attention, these trustees striving at all costs not to have to take part in litigation against the breaks. Now, the question I first asked you was, are you submitting that that's bad faith on the part of the trustees, and you disavowed that? So there's no allegation of bad faith. The way you put it, and I understand the submission, is that's a finding of lack of credibility. But I'm just struggling at the moment to see exactly what that means. analytically speaking. So is it your submission that the judge is thereby disbelieving the reasons put forward and is entitled to do so even in the absence of cross-examination? Is that analytically what's going on here?
So the way we put it is that the judge concluded below that the trustees first decided that they didn't want to get involved in litigation with the break, and then they came up with a series of reasons as to why not, and we say that meets the threshold of perversity. We might have put it higher, but I didn't put it higher at first instance, and I don't think I can put it higher on this appeal. It might be said that amounts to bad faith. I don't need to get to that threshold, I just need to show perversity. And we say it's perverse to make a decision and then to put forward a series of retrospective justifications for that decision.
Well, that's a very clear submission so far as it goes, and I'm grateful for it, but I'm still struggling with what the answer is to the question that I asked, which is the sentence that you drew attention to. What is the legal analysis of it? And I can only repeat the question.
Sorry.
Is that a finding that what the trustees have said in their evidence is to be disbelieved, even though there's been no cross-examination?
We say it's an assessment of the evidence, and it was a finding that the reasons being put forward by the trustees at the hearing, and indeed now on this appeal, was not the true motivating reason for opposing the directions. Now, it might be that the trustees below could have said, look, we're taking a neutral position, but so that the court is aware, here are some potential concerns. That's not what happened. The application below was heavily contested, and this appeal is heavily contested. And the inference the judge drew from the line of correspondence leading up to the hearing and the shifting justifications was that these trustees were straining at all costs to avoid litigation with the bankrupts. And we say there was material to support that evaluation of the evidence, and that evaluation shouldn't be disturbed on this appeal. I hope that's answered my Lord Justice Arnold's question, but if not, I'm happy to stand.
I think we've probably taken it as far as we can. Thank you.
Thank you. Can I just briefly show you where the judge returned to this point when dismissing the Section 375 application, from which there is no appeal? That's in the authorities bundle at tab 17.
Authorities tab
17. I'm sorry, my Lord, please do say it. I'm speaking. Paragraph 16 of that judgment, which is on page 381, the judge makes an observation that he finds it difficult to see why the trustees in bankruptcy raised this point about whether the beneficial ownership of the cottage vested in them only after the initial application below. And he says, I regret to say that it does remind me of the comments I made in my earlier judgment, that the trustees in bankruptcy just seem to be looking for an excuse not to get involved. I do accept what Mr. Callan says. He was appearing for the trustees on that application, that he has come into the case, taken a professional view and given certain advice and so on. That is as maybe, but in this context, I think it's merely the instrument in implementing the attitude which the trustees appear already to have taken. And that's
So in reality, that is an accusation of bad faith, isn't it? Because what's being put before the judge by counsel instructed is that this is being done on professional legal advice. And the judge says, well, I don't accept that effectively. And that's tantamount to an allegation of bad faith, isn't it?
My Lord, I think you may be right that it's tantamount to a finding of bad faith, but I'm not putting our position as being that the trustees have acted in bad faith. We say we more than meet the threshold for perversity, and we don't need to go further. But I take my Lord's comments that may be seen as a finding of bad faith. And I certainly obviously wouldn't oppose that finding if that's how it's to be characterised, being upheld by this court.
Yeah.
We say there's no basis for impugning those findings on this appeal, given the material before the judge, which I'll go through as briefly as I can. And if those findings are left undisturbed, that really should be the end of the appeal. Because, as I've already said, it's textbook perversity, if not more, for trustees to decide to avoid litigation with their bankrupts and then search around for a justification for that course of inaction. So just briefly dealing with the material available to the judge, and I'll take this as quickly as I can. The relevant background, of course, is this court's judgment in the eviction proceedings. I don't propose to turn it up, but for your note, that judgment is at Authorities 20, and the paragraphs we rely on are 15, 30 to 31, 78.
Sorry, 15, 30 to 31.
78. And 101 to 102. Now, my learned friend said in the course of his submissions, in respect of the judge's comment about encouraging comments from the Court of Appeal, that the only basis for that was an exchange in the transcript. And that's not right, because the judge, in fact, quotes paragraph 15 of the Court of Appeal's decision in the eviction proceedings in his judgment when he's setting out the grounds for the application. And that's where my Lord Justice Lewison says that the fact that Mr. Swift didn't apply for possession of the cottage was mysterious and unexplained, and had he done so, then we very likely would not have ended up with the eviction appeal. And the central point is this, and this was touched on by my Lord Justice Arnold during my learned friend submissions. There was no issue in the Court of Appeal about whether the trustees had the sole beneficial interest to the cottage, and the focus of the appeal in ground one, which was the ground that was successful, was whether the beneficial owner of the cottage or their agents, i.e. Chedington, could assert those equitable rights using self-help remedies without court order. And ground three was held over at the request of the trustees, so that the trustees could have an opportunity to seek such an order. Now, the breaks submissions on ground three and the question of the possession order were served on the 31st of October last year in accordance with this court's order. And those submissions should have removed any remaining doubt, reasonable doubt, from the trustees' minds about there being good prospects of success on the intervention. Now those, if we can briefly turn those up, those are in the core bundle at tab 7.
Sorry, just before we look at them, can I understand where you're going with this? Are you asking us preemptively to take a view on, one, the trustees' prospects of succeeding in their joinder application, which isn't before us today, and two, their prospects of success in getting an order for possession on an application that isn't before us today either?
No, I'm not asking you to do either. This is all in support of my submission that there was ample material before the judge to make that finding in paragraph 50. The trustees were looking for an excuse not to get involved in their retrospective research. And so that's why I'm just taking as briefly as I can through the chronology of how things unfolded in the run-up to the application before the judge below. So you can see the material that the judge had to make that finding in paragraph 50. I hope that
All right.
That's as far as I'm taking it. I will make some comments about whether it's really that difficult to fight a joinder application in due course, but I'm not asking this court to preempt.
No, all right, so we've got to core bundle tab 7.
Core bundle tab 7, and it's at page 175.
This is the breaks post-judgment submission, is it?
Correct. And the paragraph I wanted to draw to your attention is paragraph 2.5, where the breaks positively submit the fact that they are
Sorry.
there.
Which paragraph?
2.5.
Thank you.
I'm sorry, my lord. 2.5, where the breaks positively submit that the fact that they are their trustees is irrelevant for present purposes. These claims are claims at law and they belong to those legal owners. The relationship between them and the beneficial owners, Mr. Swift's successors as trustees in bankruptcy, so the appellants in this appeal, not an issue in these proceedings, and no order made in them can prejudice the beneficial owners. So that the breaks here expressly recognise that the beneficial interest in the cottage, in the eviction, for the purposes of the eviction proceedings, vests in the trustees in bankruptcy. But as it happened, the trustees had closed their minds to intervene even before reading these submissions. And I ask you to go in that context in the supplementary bundle to tab 11. This is a letter dated 28th of October, so 3 days before those submissions, and was in response to a letter from the first and second respondents, the majority creditors, asking the trustees to intervene in the proceedings. You'll see they refuse on the basis that there is no asset capable of realisation for the benefit of the bankruptcy estate creditors. And I'll come back in a moment to what they mean by that. And then the key passage at the end of the second paragraph is, in such circumstances, you have no positive duty to intervene. It's very clearly not in the interest of creditors for us to do so. Such an intervention will only increase costs in the bankruptcy estates without any possibility of a return to them, and therefore cannot be justified.
And do you say that that sentence, the one starting such an intervention, was not a legitimate consideration for the trustees to take into account?
No, the submission I'm going to make is that these concerns were then mitigated by the offers.
Yes, I'm not asking you that. I'm asking you whether you say it was not something they were entitled to take into account.
They were entitled to put that forward as a justification at that point in time. Save that, with this caveat, without any possibility of a return to them, we would say return to the estate would probably be a better way of putting it. But that was the reason put forward.
But surely them is the bankruptcy estates.
That may well be. You're quite
As a
right.
matter of syntax, that has to be the reference back, doesn't it?
It probably does. It may be them refers to creditors in the second line, or it may be bankruptcy estates earlier in that same sentence. I think you may be right, my lord.
Well, so it goes first to the bankruptcy estates and then to the creditors.
Yes, subject to expenses.
Yeah.
Yes, my lord. Now that rationale.
But I'm sorry, you said that the concerns were mitigated by what happened subsequently, but I thought the submission you were trying to advance at the present was an anterior one. Sorry, not trying to advance, you are advancing, I apologise, is an anterior one, namely decision taken first, reasons sought for later.
Yes. And the reason for that.
But how can subsequent undertakings to mitigate concerns be relevant to that submission? That's what I'm puzzled about.
Because when those justifications fell away because of the correspondence I'm about to come on to, a series of new concerns were expressed in correspondence. And it's that pattern of the moment that one objection is met, another objection is taken by the trustees that gives rise, we say, to the material that's entitled the judge to make his finding that these trustees were simply striving at all costs to avoid intervening and taking steps against their bankrupts. That's the submission. So in that context, can I ask you to go to tab 12 of the same bundle? This is a letter from all three respondents to the trustees, dated the 3rd of November. So in response to the letter we've just seen, and also with the benefit of having seen what the breaks were saying in the eviction proceedings. And you can see from the end of paragraph 3 that this is communicating a joint position. Paragraph 6 notes that the trustees hold the entire beneficial interest in the cottage, that it's the main, if not the only, asset in the bankruptcy estate, and also notes the contract for sale with Chedington. Paragraph 9 then sets out the benefits to the estate an intervention. And this is important in my submission because it's not just about £3,000 monthly fee being offered by Chedington. But that certainly is the offer being made in 9A that points out the breaks aren't proposing to pay anything, whereas Chedington is offering to pay £3,000. Point B then makes the point that the breaks have historically refused to leave properties when asked to do so. And that's a reference to the Axnoller House litigation, which I don't think this court was ever troubled by, but led to a 3-year long litigation, still not concluded, which necessitated a 4-week trial on liability, a week trial on quantum, which is just concluded, in respect of which the breaks now owe hundreds of thousands in legal costs to the Chedington parties and in damages for that unlawful occupation and haven't paid a penny. And in circumstances where the trustees are saying that they have very limited resources to begin with, we say that's a benefit to the estate in keeping the breaks out given their previous conduct. And then point C makes the point about the breaks possession of the cottage placing its capital value at risk, quite apart from what the trustees might have to do to get the breaks out. They claim to be impecunious, so they're not able to pay for upkeep. And if they're kept in place, because the trustees can't afford to take steps to evict them in due course, then that will obviously affect the capital value of the cottage, should they try to sell it with the breaks still in occupation of the cottage.
I thought your position was they'd agreed to sell it to you for a fixed price.
Well, yes, well, this all goes back to the argument that may or may not be had in due course about the long stop. And certainly, the trustees should be considering, circumstances where this is going to be sold to a third party, maybe Chedington, maybe someone else. What steps can we do to preserve the capital value of the cottage? And we say that's a relevant consideration. Now, those benefits were all accepted by the judge below as being material considerations. That is in the judgment, paragraph 53. Just ask you to go there. Well, I don't think we need to go there. I can just give you the reference. The benefits set out in that paragraph of the judgment is a reference to the letter I've shown you. And there's no challenge on this appeal to any of those points about the potential benefits of intervention, not just the fee, but the other points. And then going back to the letter, just do it very briefly. I'm sorry, my lord. Back to the letter, tab 12, page 153. Just to complete it, paragraph 10 sets out the steps being sought by the respondents. Paragraph 11 then contains the offer to pay the trustees reasonable costs, together with the indemnity for adverse cost risk. And then paragraphs 12 to 16 threaten the application in the absence of a response by the 7th of November. No response was forthcoming by that date, but if the trustees have written on the 8th or the 9th or the 10th saying we agree, then the application would have been vacated below. So the relevant initial decision, for the purposes of the hearing below, was the decision to reject the terms on the 3rd of November letter, and then to maintain that position in the run-up to the hearing and at the hearing itself, despite the clarifications then offered. My lords, my ladies, that may be
Yes.
time.
Right, how are we doing for time?
My lord, I think I'll need to speed up a little, but I'm conscious that I'm only entitled to half a day and I won't exceed that. I'm sure you'll stop me if I'm going on for too long.
Right, 2 o'clock.